Welcome to today's program, Time Well Spent, Session 3, Certification and Decertification. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our moderator for today's program, Kelly Kelker. Kelly, please go ahead.
Good afternoon, everyone, and welcome, as Kate said, to our third session of our Time Well Spent webinar series. I have the job of keeping everything running on time, and I was invited to take on that job because twice a year I have the privilege of updating our treatise on wage and hour collective and class action litigation. So most of what you'll hear today will be found also in the chapters of our treatise that address those subjects, which again today concern class certification and decertification issues. We're fortunate today to have three experienced class action litigators on our panel in three of our different offices. First, I'd like to tell you a little bit about Yao Li, who's in our Atlanta office, as am I, who routinely defends wage and hour and collective class actions across the country, including in Texas and New York and Pennsylvania and Georgia. And one thing to know about Yao is that he also has experience beyond wage and hour litigation, and also in areas such as ERISA, securities class actions, and consumer class actions. Ryan McCoy practices, he's a partner in our San Francisco office, and he is focused on both wage and hour issues under both the FLSA and California Labor Code, and also on independent contractor and exemption issues. He has particular expertise in the areas of transportation and logistics, which is, of course, a hot area these days, including litigation and day-to-day counseling advice. And third, we have Michael Afar. He's in our Century City, Los Angeles office, and he spent his entire career litigating class action and PAGA issues particularly, and recently obtained successful results on difficult certification issues involving regular rate of pay issues. He's the co-editor-in-chief of Seyfarth's Litigating California Wage and Hour Class and PAGA Actions Treatise, which is a separate treatise from our Wage and Hour Collective and Class Action Treatise. So with those introductions, we're going to start today with Yao talking generally about class action issues, and then Yao will turn it over to Michael and Ryan to talk about some California-specific substantive and procedural issues. Yao?
Thank you, Kelly, and thanks to everyone on the call for joining us today. I'll just dive right in because this is a pretty weighty, big topic. Much of it is covered extensively in our treatise. So I'll just start with a high-level overview of FLSA collective actions and how they are different from and sometimes similar to Rule 23 class actions. First of all, looking at the FLSA, it's an opt-in procedure, which requires participants to actually consent in writing to join. It's very different from the Rule 23 world, where it's an opt-out procedure, where all class members are automatically in the case unless they take affirmative steps to get themselves out. Under the FLSA, we traditionally have a two-step process that's changed a little bit, most recently in a couple of circuits discussed at our last session, and I'll touch on that a little bit today as well. But generally speaking, we're looking at a first step of a not terribly well-defined, similarly situated standard, generally seen as quite lenient, and that's followed by a second step decertification process that goes into a more exacting standard. Rule 23, on the other hand, upfront asks for a much more demanding set of requirements, including numerosity, commonality, typicality, and adequacy under Rule 23A, and then most often also under Rule 23B, looking at predominance and superiority. That may also sound somewhat similar to looking back at the FLSA decertification standard, where courts traditionally are going to take a harder look at 3 different factors. For example, the disparate factual and employment settings of individual plaintiffs. Second, defenses available to the employer that are unique in particular to individual plaintiffs. And then third, fairness and procedural considerations. So we see there with that traditional second step decertification process mirroring in many aspects the more rigorous upfront standard called for by Rule 23. And then lastly, this is a developing change perhaps in how FLSA cases and Rule 23 cases may differ. Under the FLSA, more and more courts have taken the position that judicial approval of settlements is not required. And that, of course, is very different from Rule 23, which always requires judicial approval of those settlements. Let's move to the next slide, please. So why do we sometimes see plaintiffs come with Rule 23 cases in addition to FLSA cases? There are many reasons. Just a few examples here. Often plaintiffs get a longer statute of limitations. We've got just 2 or 3 years under the FLSA versus state laws, such as New York, for example, could take us all the way to 6 years. State laws often allow for higher protections for employees, which result in additional liability for employers, such as Michael and Ryan will talk about later. In California, we've got the meal and rest breaks. And then looking again in New York with their wage theft law, they've got wage notice and wage statement requirements. Plaintiffs also look to Rule 23 cases because that might allow them to file in state court, where state courts don't always look at these cases with the same rigor that federal courts do. For example, under Walmart v. Dukes, federal courts have to very rigorously scrutinize whether the plaintiffs have satisfied all of the Rule 23 requirements. State courts don't always have to do that. And then one other reason we've seen an increase in Rule 23 state law class actions is partially as a response to some personal jurisdiction decisions in the wage hour space that have followed the Supreme Court's Bristol-Myers Squibb case. 3 circuits, the 3rd, the 6th, and the 8th Circuit, have held that non-resident opt-in plaintiffs may not join collective actions against out-of-state companies for out-of-state work. And that simply means that in many cases, plaintiffs are not able to have their chosen forum for getting a nationwide collective certified or even heard. So one response that we've seen is that they will in turn splinter their own case and file sometimes in multiple states, going after state law classes based on state law violations. Next slide, please. So how can employers respond to Rule 23 class actions that we see increasingly? One thing they can do right from the outset is thinking about removal, getting out of that state court and getting into a federal court that's going to be held to that higher Walmart v. Duke standard. If there's a FLSA claim that's included, we have easy federal question jurisdiction. But sometimes the plaintiffs get savvy and they drop that FLSA claim. They have only the state law cases. In that case, we have to think about whether we have a plaintiff that meets the threshold, $75,000 for general diversity jurisdiction. And that may even include other opt-in plaintiffs that, for example, under the Bristol-Myers line of cases, are considered to be party plaintiffs. And especially in some states where we have that longer statute of limitations, like the 6 years in New York, we could see, in those cases, the damages may add up. And even if not, there's always CAFA to look at whether they meet those requirements. And another response could be a motion to dismiss or a motion for summary judgment. Those are beyond the scope of this webinar, but they are extensively discussed in our treatise. Next, employers can think about making a Rule 12F motion to strike the class allegations. Those allegations may just even be by looking at the complaint and taking the well-pled facts as true, they may not rise to a level that would satisfy Rule 23. So right off the bat, if the case is amenable to such treatment, a Rule 12F motion to strike might be in order. Some cases, some courts will sometimes convert those motions to a motion to deny class certification under Rule 23. That's another avenue to respond, and that one, unlike the Rule 12F motion, is not limited to the beginning of cases, and in fact, is not limited in time to any particular point, up to and including the close of discovery. It can be whenever the employer has gathered sufficient evidence to show the court that the Rule 23 requirements can't be met. And often we can use that method to sometimes defeat class certification in cases where the commonality or predominance or typicality aren't satisfied. And those cases might include, for example, misclassification cases where courts are going to have to look very closely at individual job duties, maybe off-the-clock cases where courts are going to have to really think hard about how plaintiffs are going to prove their damages, prove liability even, that they worked off the clock. And then in another consideration to think about is in hybrid cases, and here this harkens back to some differences and similarities between the decertification standard and the Rule 23 class certification standard, and that in the Fifth Circuit, for example, under Swales, and then joined later by the Sixth Circuit with its own take on getting rid of the Lusardi two-step method, we see this mingling of the certification, what was previously the lenient conditional certification standard and the much more rigorous decertification standard. That is, in those hybrid cases, that's really going to impact the sequencing of motions, the types of motions that are going to need to be made, and the proof gathered through discovery or otherwise that might be brought to bear in those motions. And then finally, some states have their own ways to creatively get rid of some of these class actions. For example, in New York, they have a procedural rule that says plaintiffs only get 60 days to move for class certification after the time to respond has expired for all defendants. And that's actually a pretty hard and fast rule. And the failure to adhere to those 60 days might actually end in dismissal of the class claims with prejudice. So again, it's very important to look at the individual states under which these cases are brought. Next slide, please. So just wanted to move quickly now into a few more recent cases that have been interesting and bear on some of the Rule 23 requirements. In the arbitration space, for example, there's a California case, a California federal court held that there wasn't any numerosity because after the arbitration agreement was enforced, only 16 potential class members were left. In another California federal case, the court found a lack of typicality because the named plaintiff was not subject to an arbitration agreement, and therefore she lacked standing to assert defenses on behalf of previous class members who were bound by arbitration agreements. So there's a couple of different ways that even the very existence of an arbitration agreement is going to affect whether a class action gets certified or not. And then a Seventh Circuit case in Anderson, also affecting numerosity and hybrid cases in particular, really highlights the tension between what plaintiffs have to show to get a class action certified. There, the district court denied certification of the class because it found that the proposed class of 37 all worked in the same facility, and therefore FLSA collective certification was a practical means to accomplish joinder. And based on that, no need to have a Rule 23 class because they could just pursue their claims as a FLSA collective. And so at the same time, that is going to cause plaintiffs to have to think about, well, if they want to show that joinder is impracticable, to show that numerosity is satisfied, they might need to expand the class, and that may cause problems with typicality and commonality and predominance. So it was very interesting to think about. Next slide, please. Some other cases, first on superiority, this is out of the Third Circuit. There, the court, the appeals court said the district court had erred in sending FLSA collective claims to trial before deciding class certification. If the district court is going to go ahead and try the FLSA collective claims, that shows that having a class action later on is not superior because, as the court said, quote, as a practical matter, what work is there left for the class action device to do? So that case really shows us the importance of considering the sequencing of having the Rule 23 class action motion versus the trial, showing that a trial before certification approach doesn't work. Just lots of consideration there in trying to formulate a trial plan and how to accomplish getting to the merits. Next, we're looking at a couple cases out of California federal courts on damages, and again, this goes to the importance of having having a trial plan and putting plaintiffs to the burden on the plaintiffs to come up with an actionable trial plan. This goes to in the wake of, for example, Tyson Foods, which allowed some forms of representative sampling or statistical evidence to come in at the certification stage. Courts have said that that isn't enough. It's really important to consider fully what kind of statistical evidence exists and whether it actually goes towards satisfying commonality and predominance, for example. So the courts there have denied class certification based based on the fact that damages can't be established that way class-wide. Next slide. And then finally, just to touch back on the last difference, or one of the last differences is recently courts have looked at the fact that the settlements under the FLSA, the text of the FLSA doesn't necessarily require judicial approval of settlements. We were seeing cases out of Arizona, Pennsylvania, Wisconsin there. Important to know that there is precedent in the 11th and 2nd circuits that go the other way. Next slide. And that's it for the nationwide Rule 23. And so now I just want to turn it over to Michael and Ryan to discuss what they're seeing out in California.
Hey, thanks, Yao. I appreciate the update on all the things that you're seeing. And at the FLSA, I mean, just seeing all of that and seeing all the developments over the couple of years, it really highlights that in many ways, the federal litigation under the FLSA is fundamentally different than what we're seeing in California, but in many ways it's the same. And oftentimes the strategies can be employed in California just like they can in the FLSA. But certainly because we've dedicated an entire section of this webinar to California class issues, you can see how important it has been over the last 5, 10, 15 years. I think first off, what has been a notable development in California is the class action jurisprudence has not developed nearly as quickly as it was previously, because we've really seen an explosion of cases under the Private Attorney General's Act, otherwise known as PAGA. And the unfortunate thing about PAGA is that the courts have held PAGA is effectively a lawsuit on behalf of the state of California, and therefore the logic goes that the traditional requirements of class actions, including all of the things that you just talked about, Yao, like typicality, manageability, adequacy, commonality, those things don't apply in PAGA. And so class counsel, who were previously filing these putative class actions, are now filing a lot more PAGA actions because they're finding it a lot easier to litigate those claims because of the way that the courts have interpreted. I mean, we'll get into this shortly, but last week, the California Supreme Court just heard oral arguments on another important issue in PAGA jurisprudence, being manageability. But class actions are still important, and so are the strategies. And that's, Michael, you know, how has the jurisprudence developed for those claims that we are seeing?
Yeah, absolutely. You know, I think what we're seeing is, at least with substantive topics like meal periods or regular rate, we're seeing a lot of the plaintiffs bar pushing the courts to take what may have traditionally been individualized issues and pushing them into more of a class certification type problem. You know, things like regular rate and rounding have always been class certification issues that have been hot because it applies to a broader group of employees. And so there's been an uptick in those types of claims. You see a lot of plaintiffs' lawyers that are being very honest about just, we're going to stop wasting our time with claims that historically have been more subject to individualized issue attacks and just focusing on gotcha type claims, especially in light of a lot of California you know, holdings that have emphasized those types of claims. But even for traditional things like a meal period claim, where we've always argued you have to look into the who, what, where, when, why of whether or not a meal period was provided, you see a lot of the plaintiffs' bar taking advantage of recent cases like the Donahue decision in 2021, where the court held that there's now a rebuttable presumption of potential liability if there's noncompliance just on the face of records. And you see plaintiffs trying to turn that into a class certification issue by saying that rebuttable presumption is something that applies to everybody, and a court should grant certification on that issue. And then anything else about whether people were provided or not provided goes to a damages issue, or is not something that is so individualized that it predominates over common questions. Thankfully, we have seen courts push back a little bit on that and actually give us a little bit of case law that can be helpful. There are a couple of decisions, one in 2021 and one in 2022, where the courts have said, even post-Donahue, that it doesn't satisfy the requirements for class certification. If anything, the rebuttable presumption emphasizes that there still have to be individualized determinations as to whether or not employees receive these types of breaks. So it's not all doomsday, but we definitely see plaintiffs trying to take advantage of that and trying to shepherd everything into an issue of class certification where realistically it's not. Next slide, please. And so that sort of gets us back to, the traditional toolbox of what, would be most helpful to oppose class certification, or at least to get to a decertification stage if a claim is ultimately certified. And that's the emphasis on compliant policies, where you're starting from a position where the only common evidence applies to everybody is a lawful position. You have a compliant policy, it says everything you need to do, and anything to the contrary of that would lead us down the road to individualized issues. As Ryan noted earlier, one of the things that we're seeing with the rise of PAGA claims is an attempt to get around the procedural requirements, but there still is an overarching trial plan requirement, right, Ryan, for these types of claims, whether it's on a class cert stage or whether it's through a PAGA case.
I mean, sure. That is always the argument after and before the Duran decision about 10 years ago, is that the burden is always on the plaintiff at all points during the case, before and after certification, that they have to provide a trial plan that shows that they can try these claims in a manageable way. And so oftentimes what we'll see is we will talk to our friends on the other side and they will say, well, I will be able to prove this claim on a class-wide basis because I can show the policy, or I will give the testimony of my client, and my client is going to say that this is common across the entire class. And we put our foot down and we say, no, that's not how it works. There are 1,000 other employees out there that we have to talk to, not only them, but their managers, to talk about their individual experiences about how did they record their time? How were they provided their meal periods? Did they work alone? Well, who is going to be able to say whether or not they were provided a meal or a rest period? And that gets back to Mike's point about compliant policies. It's really important to have the policies written in an airtight way in 2023, because that is the first thing that plaintiffs' attorneys are going to look for, because it's the easiest way to certify a claim or litigate a PAGA claim, is if you're not providing a timely meal period. But hopefully you do have a compliant policy so that you can argue there is no way to manageably try a claim in the absence of an unlawful policy. So even after certification, you can file a motion for decert based on new facts, new law. But we are always looking at what the new law from the Supreme Court is going to be, because a lot of these arguments that we have been making for the last couple of years as to manageability, although there was a split between the courts of appeal, the California Supreme Court held its oral arguments on whether or not PAGA has a manageability requirement, and who knows how it comes out. But Mike, did you have any thoughts on the arguments and how that may impact strategies going forward?
Yeah, absolutely. There seem to be, it's always, easy to assume that the California Supreme Court is going to come out with a holding that is not favorable to employers. But reading, between the lines and listening to the oral argument in the Estrada case last week, you can see the California Supreme Court actually grapple with how do we still keep intact some sort of procedural tools, even if it's not explicitly provided for under PAGA. How do we, it's not going to be quite like a class action, but maybe there is some overlap. Maybe there is some common ground that we can take from what we see in the class action sphere and see why it's useful and beneficial to have in the PAGA sphere. And whether that means, ultimately limiting a court's ability to fully strike or fully dismiss PAGA claims that are unmanageable, it remains to be seen. It seems unlikely that the Supreme Court is going to go that far, but in general, holding some sort of manageability requirement in place definitely still seems likely. And then it gets back to the same thing we look at with class certification or decertification, which is, are there still ways to cut down the claim as it is? Are there ways to narrow down the group of employees, either through arbitration agreements or through factual arguments? As Yao mentioned, Are there ways that we can look at policies and whether policies apply for only particular periods of time or things like that? There still is going to be a lot that we can learn and use from what we've learned over the last decade on the class action side that can still help us attack PAGA claims. And I know we're sort of getting to the end of our time, but if anybody had any questions, we're happy to stick around for a little bit. But otherwise, want to make sure we can read off the CLE code, right, Kelly, before it gets too late. If we go to the next slide, please.
Yes, thank you. Thank you, Michael. And Ryan and Yao, today's CLE code, and I'm not making this up, is SS, as in Seyfarth Shaw, 1234. SS 1234. So thank you all for joining us. And as Michael said, our chat box is open, and I'm sure that our panelists would be happy to hang around for a few minutes if you have any specific questions for any of them about what they discussed. And I'd like to also take this opportunity, next slide please, to remind you of the upcoming sessions in our webinar series on time well spent. You can see them listed there. And number 4 will be upon us soon, and it is on December 5th. And it's the rise of mandatory arbitration agreements, and that will be a lively session since there have been so many developments in that area recently. Next slide, please. Like to also remind everybody that our treatise is available for purchase, and you can reach out to any of us or to Kate to find out how to get that. And that's all that I had. And we thank you again for joining us, and hope we'll see you on December 5th and thereafter. But again, if you have any questions, feel free to put them in the chat. Thank you very much for joining us. Bye-bye.